don't just sign a performance improvement plan that gets put in front of you. If you have some sort of response, or you're saying, hey, well, I just reported that you guys were not paying me correctly, and
now you put me on this performance improvement
plan,
right?
And now you put me on this performance improvement plan. If that's what's happening, you should write that right before you sign. That way, when the jury sees the document and it gets put in front of them, and you say, look, I told you about the retaliation back then, even before you fired me.
Right.
And so,
that's a great tip, by the way. I think that a lot of employees are probably in a position where when you get a piece of paper like that, you don't feel like you're in a position, right? Your employer is telling you, we're not satisfied with X, Y, Z. It's an odd place to be as an employee to go, well, I'm not satisfied with ABC, right? At that time. But it's really important. That's a great note. I'd never heard that advice before.
And also, if you're sitting in a room, just from a psychological perspective, if I'm sitting in a room by myself and, I'm adversarial because I'm an attorney, but most people really aren't, and they want to just keep their jobs, right?
Right.
And so if I'm sitting in a room by myself and I have 3 people telling me how bad I am, I really am being pressured to just sign my name and give you this document back. And so maybe the response is, okay, let me take a look at this. Let me take it home. Let me talk, about it with my partner, and I'll bring it in signed tomorrow, right? So you don't feel like you have to sign on the spot. And if they are pressuring you to sign on the spot, well, maybe that's something you should voice and say, hey, I'm not comfortable signing on the spot. I have my own issues. Maybe you're comfortable voicing those issues to the 3 people in a room at the same time. Maybe you're not. So maybe you say, hey, look, I really need to take this home. I'll put in writing what my issues are.
And that's, we do get a lot of employees that call because usually those meetings are pre-scheduled and they kind of see what's coming. And so they call us and they ask us, what are my rights? What can I do? And that's the kind of advice that we can help give them. The other thing, Anton was saying, just don't sign whatever they give you. If you are terminated and they are offering you any type of severance package, don't sign it immediately. You're allowed, especially if you are over 40, you are guaranteed 21 days to review that and decide if you want to sign it or not. And then even after you sign it, you have 7 days to take it back. And severances, we always say, can be negotiated. And so you really want to talk to an attorney if you are offered any type of severance package and see, maybe you can increase the payout they're offering or the insurance, things like that. And the biggest reason to talk to an attorney is when you sign that severance, any lawsuit you have is gone. You are signing away your rights from the beginning of time until the day that you're terminated against the company. And so that is a huge right that you're giving up. And it's also a huge incentive for employers to come to the table and negotiate for severance because they want that waiver.
Let me ask you about that because I know that in recent years the I think it's the federal government, but maybe stateside too, that is looking a little bit less fondly on non-competes, right? And they're reevaluating that, right? And I think that with some of the things that you saw out of just really nasty employment practices and also just like abuse and things like that were happening behind the scenes, that they're reevaluating that. So I want to be clear on that because I think that this is a little bit more or a bigger picture than what we're talking about in this video. But just to be clear, if I sign that agreement and let's say I felt like I was in an abusive or harassing environment, am I signing away my ability to come forward in that situation as well?
If you sign that severance, yes, there's going to be detailed language in there that says you're giving your any discriminatory or discrimination claims, any retaliation claims, even if you slipped and falled on the property, any of those claims, wow. You're admitting that you're paid up to date, that you're not missing any wages. And one of the things that you will sign on that severance is that you will, if you have a non-compete, that you'll abide by it and that you acknowledge that it's there. I know a lot of people know about the FTC taking down or, saying non-competes are unenforceable. There was a federal court ruling that I think it was the Ninth Circuit that could be unconstitutional. And so there's what's called a preliminary injunction right now. And so that law or rule, really as it is, doesn't go into effect right now. And so all non-competes are still valid in the sense that the employer can offer them and ask the employee to sign them, but there's still limits on those.
Okay.
And so you can have, usually your non-compete is like a year, 18 months, 2 years. Sometimes there's always a duration on it. And there's also a geographical location. And sometimes if your company is very specific and you have very specific competitors, maybe those are mentioned in the non-compete. Most courts, at least in Pennsylvania, don't look too fondly on non-competes,
right.
especially if you're not a higher level manager, C-suite, those kinds of, if you're just, a lower level employee, or home care workers actually sign a lot of non-competes. And courts don't like to enforce those because it hampers their ability to
get
find
other
a job.
work.